speaking, otherwise remote participants may be unable to hear the next speaker. The first item on the agenda is the emergency evacuation procedure. Notified that Furrow is actually planned this afternoon. If the alarm sounds, those in attendance should leave via the exits indicated there to my right and there behind you. Please do not use the lift. You'll be directed to the out into the car park and cannot re-enter the building in the initial hold, please. Anybody who requires any extra assistance, please make themselves known now, please. Please can the panel confirm who will be chairing the meeting this afternoon?
Point of order. I raise a point of order under 2.4.5.4. I'd like to ask the panel members if they have received standards hearing training as required by the Constitution. Thank you.
Assist, Chair, that I'm alive to this issue because it's in the Constitution, and we mentioned it in the Constitution group only the other day. So I spoke to the panel members some weeks ago to confirm that they were happy and content they had sufficient knowledge of standard procedure, which is the specific training that's required to train on standard procedure. They would be happy to undertake the hearing, and they all confirmed to me that they had sufficient training knowledge of the procedure in order to be able to do so.
Just for the minutes, then, what you're saying is that it was an informed discussion, that they feel happy, but there's been no discussion on formal or records kept or formal standards training.
It wasn't a discussion about the record of the training, it was a discussion about whether they were able and competent to attend the standards hearing today and were happy with the procedure, which is the training that's suggested under the Constitution, and all confirmed to me that they were happy with the procedure. So for perhaps the Chairman, Councillor Wise, who I then discussed the procedure with when we had a meeting.
No, thank you for clarifying that. But there's been no formal training as required in the Constitution, which is worth minuting. Thank you.
We're going to move on to appointing a chair for the meeting. If my colleagues are agreeable, I'll put myself forward to chair this meeting.
I'll raise a point of order under the Localism Act 2011. I submitted some evidence to be put in, namely freedom of information request, a witness statement, and I was informed that the chair of standards, which is yourself now otherwise, refused to put that information in, which means you must have looked at that information. And I wondered, have you been made yourself predetermined by looking at evidence and deciding which evidence should be submitted and which evidence shouldn't? And the legal officer give his opinion on that, please.
Thank you, Councillor. Councillor Wise would have been entitled to read the pack prior to deciding whether or not to actually chair the meeting.
That's not the question. The question was, by excluding evidence, he has been predetermined.
In my opinion, it's not predetermined by excluding evidence. Well, excluding evidence is not predetermined to the information contained in the pack.
So that's a point of clarification. He has excluded the evidence is not in the pack because he is determined that it's not relevant information, which I think it is. And I think under the principles of natural justice, even the principles of the Human Rights Act, Article 6, even so there could be an argument that they don't apply to this hearing, there is still the basic principle that the fairness of any tribunal or any hearing should follow the basic principles of natural justice, due process, and Article 6 of the Human Rights Act. I don't feel by looking at the evidence and saying that this evidence cannot be submitted, even a witness statement, is not, you can only do that if you've based a decision which leads to the mind to a fair-minded person that there's been predetermination. That's the requirement under law. Now, I'm quite happy if this continues. However, I would like it noted that I have raised this objection because of any subsequent appeal or complaint to the local government ombudsman they will be looking at the due process that was followed.
Mr. Palmer, the legal officer has said that he doesn't believe that Councillor White is predetermined. There are other reasons why he could have looked and said that something wasn't admissible without being predetermined. It could be that that does not make him predetermined. He just means that it's not legally relevant. But the legal officer has ruled that he believes he's not independent, he's not predetermined. So your comments have been noted, but I think we just need to move on now.
Yeah, nice to meet you. Sorry, Chair, just for clarity, I wonder whether it may be helpful if you could confirm whether or not you are predetermined.
No, I don't think that I am. You know, as the chief executive explained, I was given advice on whether I felt that what was going to be brought forward to this was what we needed in order to proceed with this hearing, and that the information contained would be relevant. But we're going to move on because we've had this, but nobody here has yet even had an opportunity to introduce themselves, to even know who each other are and in what capacity they're here. Yeah.
Sorry, do we want to agree? I'm happy to agree that you are chair for the meeting.
Yeah, everyone's agreed. Thank you. Okay, so I'm now formally welcoming everybody to this standards hearing meeting. I'm Councillor Ashwise, I'm chair of the standards committee, and I'll be chairing this meeting. I'll just ask the other people who are here to introduce themselves as well, just starting with my colleagues on the panel.
Councillor James Hunt, member of the Standards Committee and obviously on this panel.
Councillor Hamper, again, member of the Standards Committee.
Gary Rowan, legal advisor.
I'm Robin Harris, I'm the council's monitoring officer, and I'm also sitting in the seat of the investigating officer for today.
And Mr. Reid, I'm chief executive and head of paid service.
Joe Millard, Democratic and Electoral Services Manager.
Would you like to introduce yourselves as well?
Patricia Richards, independent person.
Chris Webb, independent person. Councillor Richard Palmer.
Okay, thank you, everyone. So now we just need to move on to declaration of interest. If there are any declarations to be made, can they be done so, please? Okay, no declarations of interest. We now move on to a vote about the exclusion of press and public. Given the substantial amount of blue paper material, I would like to move that the press and public are excluded from the meeting. If my colleagues would like to vote on whether they're in agreement with that proposal.
Point of order. I believe, first of all, there should be a discussion to why it should be or why it should be public. I think to just move to the vote without hearing reason would be breach of process. Thank you.
Okay, well, okay, I've outlined why I would like to move it. If anybody else would like to address that point, we obviously also have the investigating officer who is entitled to speak. So we'll start with that.
Thank you, Chair. So in my view, whilst standards hearings can be public, in my view, this hearing should be in private. It contains exempt information in the majority of the pack. In particular, it contains information about individuals and information about individuals who may be identified. Fundamentally, the starting point of this matter is an allegation that a council officer is corrupt. And that if we agree that this meeting then becomes public, the pack becomes public, and the council would then publish that paperwork, and therefore the statement that was made that was potentially a defamatory statement would be in the public domain and would have been published by the council. Also, the papers were not put together in relation to this with a view to them being public. Though they were released, Councillor Palmer promptly without any form of redaction, and therefore there is private personal data contained within the papers, which would not be contained in the event that they had been, for example, obtained under FOI, because they weren't being obtained under FOI, they were being obtained for the purposes of standards hearing. And so they were capable of being exempt on that basis, in my view. The hearing needs to be exempt as well, so that all parties can speak on those papers freely.
Councillor Palmer.
I'd like to come back on that because, well, let's go through it, shall we? Local Government Act requires all local councils to have a constitution that covers standing orders to delegate to blah, blah, blah. Let's look at the reasons. Should the report and the reports of the hearing be held in private? My view is no. All the information in this report is within the public domain, including names and emails. It's either on the planning portal or, and I think it's a bit disingenuous because my request, the information was made under the Freedom of Information request. It was released to me by the Freedom of Information Officer. The Information Commissioner is quite specific. Release of information under the Freedom of Information Act is released to the world. Public authorities are not allowed to take account of the identity of the person making the request or the motives when deciding what information will be disclosed in response to a Freedom of Information request. I could have used a web-based app. What do they know? Where all correspondence and FOI request is open to the world on the World Wide Web. And so is this information. This information is already in the public domain. So to hold it in private would be a breach of, I feel, due process. The other reason is that this matter is of public interest. It's of interest to my residents. It's of interest generally because it's a planning matter. And planning matters are generally of a public interest. The officer concerned, the case officer concerned, has already threatened and is at liberty to take defamation. And defamation would be held in a public hearing. So he's already, by his actions, wishing to go public. A ward councillor representing his residents' views and comments on a matter going to the planning committee, taking up issues when asked by the parish council who felt they were being ignored. This matter is of local concern. It is a planning matter and planning matters are very locally concerned. The Local Government Association, where a committee is convened to assess an allegation, it is the ordinary committee of the authority. Oh, that's an interesting point. It is an ordinary committee of the authority. If it is making a decision and it is subject to the notice and publicity requirements under Section 12 of the Local Government Act, the political balance rules apply unless stated in the Constitution. Perhaps the monitoring officer can show where the political balance rules don't apply, in this case, to the hearing panel, where it's stated in the Constitution. However, this is from the Local Government Association, while there should be a presumption that the hearing or an investigation would normally be held in public, there will be a strong presumption towards an assessment being treated as exempt information. The meeting may have to consider unfounded and potentially damaging allegations, complaints about a council, which it would not be appropriate to make public. And I could see you could read that over to an officer, but the information has been made public and is in the public domain. And the officer concerned wishes to go to a public court. So,
Councillor Palmer, I'm going to have to ask you to stop because unless you're getting close to completing your point.
well, I am. I've got
Okay,
that to
go
say.
ahead.
And it's nevertheless, the meetings deal with exempt information. Well, it's not exempt, it's in the public domain. And I think there's an interest in the fairness of justice, in due process, in an open and public hearing, because I think the public have a right to know.
Okay, I appreciate your comments, but these papers have been shared with us and treated as such as blue paper material, which, as you know, is restricted. Upon advice about this, I still feel that the meeting should progress subject to a vote in that way. This isn't a meeting of the planning committee. This isn't a courtroom. This is about a breach of a code of conduct, an alleged breach of a code of conduct. That's what we are here to consider. And I think it's in the interests of all parties that it proceeds as such. So given the advice that we've received so far. I take on board what you said, but I'm going to move to a vote to exclude the press and public. And that's subject to confirmation. So if we can take a vote on that, please. In favour. Okay, so we're going to move to conduct this meeting with the press and public excluded.